Binding arbitration, it's something people are talking about because it seems everywhere you turn you have to agree to terms of service when you're working digitally through an app, and you're agreeing to arbitrate any disputes that you have with the supplier of the goods or service instead of taking them to court if you have a dispute with them. And frankly, that's fine. If it's really just a dispute over the purchase, it's probably a small purchase, and you're probably not even going to take them to a litigated dispute. You're just going to swallow it and say, I'm not dealing with that merchant again. That's the world of regular commercial transactions. But what happens when an e-hail service like Uber, who has 7 million drivers globally circling around looking for fares or looking to get arranged trips, who could hit you at any time, and you have that Uber app on your phone and you've agreed that you're going to arbitrate all disputes against Uber. Well, let me tell you, the Uber terms of service do not say you have to arbitrate claims against us when the claim arises out of a particular transaction with Uber. They just say you will never take us to court. And that holds true years after you downloaded the app and they run you over while you're walking through the crosswalk in a transaction with an Uber driver that has absolutely nothing to do with any service you're purchasing from Uber. You may not have ever had any commerce with Uber for years, but you've still agreed that you're going to submit every dispute with them to binding arbitration. Well, I have been involved in litigating arbitrability issues for practically my entire career as a lawyer. Back in the 90s, I was involved in a national class action on behalf of servers in Hooters restaurants who were being sexually harassed and assaulted by the owner of Hooters of America, his brother. And they were being forced into arbitration over these disputes that involved actual sexual assaults under a term and condition of employment that said, if you want to work as a server for Hooters, you have to submit yourself to our binding arbitration program. Well, what is arbitration? That was the issue in Annette Phillips v. Hooters of America that we litigated back in the 90s. And it turns out that Hooters arbitration program they had the servers sign on to allowed Hooters to pick who was an approved arbitrator. They could just put the 5 people who they trusted, their own company's lawyers, on that list, and that was their arbitration program. We brought it in federal court. We got an injunction against the enforcement of the arbitration clause. It went up to the 4th Circuit, and the 4th Circuit said, this is not arbitration. So arbitration is private dispute resolution, but it's supposed to have substantial fairness. Yes, it's expedited, it's more efficient than full measure litigation in court, doesn't have all the procedures and the protections for all the parties, but it has to have a modicum of justice that it delivers. It has to be even-handed, and there has to be at least a chance for each side to potentially prevail in their claims in arbitration for it to actually be arbitration. And the problem is, because it's a completely private system, it's not really regulated. It only comes up when people challenge it in court that this is bogus arbitration, like in that case, Phillips v. Hooters. Well, arbitration, when it's involving tort claims, like you've been hurt by an Uber driver who hit you, that's a very explosive issue, because you can have severe life-changing injuries, and under our Anglo-American jurisprudence system, you have a right to take those claims to a jury of your peers. You are not going to get the kind of justice you will get in court from an arbitrator, and there's a few reasons why. But most fundamental is that in an arbitral setting, the repeat players always have more influence over the arbitrators than the one-time players. And in Uber's arbitration system, Uber is the repeat player, and you will get hauled in front of an arbitrator who makes all of their living off of Uber arbitrations. And you're just one case of one person who got hurt by Uber. Well, you know what? I worked as a labor organizer before I was even a lawyer, and I saw the power of repeat players in the arbitration system. It was sometimes the case that unions were the repeat players, and the employers were the ones who were at a disadvantage in front of those arbitrators who wanted to make sure they would keep getting picked by the unions. And so they put their thumb on the scale of arbitral justice. The exact same thing happens in reverse with Uber, who's a repeat player in their arbitration program. Those arbitrators want to stay on Uber's arbitration good list and not get on their shit list, right? If you have one claim against Uber, yeah, they took off your arm. You're only going to have one claim against them probably in your whole life. Do you want to arbitrate that claim, or do you want to bring it in court in front of a jury of your peers? So it's very important when you think about agreeing to arbitration, even though it's just one of 100 different terms and conditions buried in the service agreement you click on and agree to with your app, you really ought to think twice, because it's one thing when you're signing up for the Fandango app and you didn't get the movie you wanted, you thought it was a bad movie, right? Or something like that. You arbitrate that dispute, who cares? But if you have a severe life-changing injury, you or your child who you're responsible for, and you have to look out for their legal rights, and you've waived those rights by agreeing to arbitrate against a company like Uber, you're in a bad place.